Good evening and welcome to Law Talk, the show that brings the law, the Constitution, and the news to you each month on a regular basis for your education. Tonight, I'm James Barrett with Mark Malachowski. We're very fortunate tonight. We have two guests in a specific field we're going to discuss. First, to my right, we have John McDonald, an expert in the insurance and the driving while intoxicated field. And we have May McDonald, an expert that assists John in his business practice. Good evening, John.
Good evening, James. How are you?
So, Mark, how are we approaching this subject tonight?
Well, first of all, we're going to talk about a famous basketball star, used to play for the Clippers, Lamar Odom. And he got in a little trouble the other night, was driving on Highway 101, got pulled over. Apparently, the police thought that he was under the influence of alcohol and perhaps some drugs, and so they arrest him for a DUI.
Well, is there anything special about this case?
Well, it's a pretty high-profile case because he's a celebrity, but also it's kind of interesting because he refused his test. Now, first of all, there's several tests that the police want to administer when you get pulled over under suspicion of drunk driving. And John, what are some of those tests that the police might administer when you get pulled over for a DUI?
Well, they're commonly referred to, Mark, as FSTs or field sobriety tests. And what happens is when the police, when they light you up and they pull you over, more often than not, they're in the hunt. They're looking for somebody that they can qualify for as having been under the influence. So what they need to do is they need to build a case. Part of building that case is implementing what's known as the FSTs, the field sobriety tests. So,
and so these tests they're trying to measure your coordination and your responsiveness. They might ask you to, say some sentences or count to a certain number or close your eyes and do some balance tests, something like that.
Are we
Correct.
required to take those tests?
No, you are not. There's, for instance, there's one. It's a horizontal gaze stigmas test. And they need to hold their fingers 8 inches out, and you follow the fingers. But what that's doing is you're not required to do it. But by the officer doing that with you, then what they're doing is they're putting down on their little chit sheet. Okay, well, you know what? You couldn't go the full, James. You couldn't go the full 45 degrees. So we're going to say that my finger was 8 inches away from your nose, and you did not qualify. So in my estimation, you are under the influence.
So they're saying if your eyes quiver at a certain point or start to waver, then you're under some kind of a brain problem. But that could also be the flu or fatigue or anything else, or it also could be, just a misjudgment of that angle too.
Right. What they're saying is that you're impaired.
Right.
That's the FSTs are used to support the officer's intent to implicate you on having operated that vehicle while impaired or intoxicated.
So what he's actually doing is he's starting to build his case from the first moment. So it's not just the pullover and he asks you to get out of the car, but it's more that he's going to start building evidentiary support for his interpretation that you may be intoxicated.
For me being the officer, for my having that case filed with the DA, for me to be able to build a case for the DA so that I can have you convicted of a DUI.
So when you refuse that, though, what's their next step?
Well, first off, it's your constitutional right to refuse it. You're a private citizen. You have they do not possess the authority to force you to take these field sobriety tests. So the next step, and this is one of the ways that they get the individual to take these tests is, well, you know what, Mark? Either you take these tests, or what I'm going to do is I'm going to take you to jail. So you either do these field sobriety tests, or I'm taking you to jail. Well, at the end of the day, they're going to take you to jail anyway.
Or at the end of the night.
At the end of the night. Yes, at the end of the night.
Usually.
Hopefully it's the night.
At the end of the early morning, yeah. So, okay, so what about if they bring out something they want to do like a breathalyzer test? I think they call that the preliminary alcohol screening
test, the
Now,
pass.
what about that? They want you to blow into something there. Are you required to take that?
You are not obligated to take that as well.
Well, but I think if you're under 21, isn't there a certain age limit?
If you're under 21, then it's, well, under 21, zero tolerance, so you could be a .01.
Yeah, I think you may have to take the pass if you're under 21.
Yeah, the legal definition is if you're over 21, it's .08. At that point, you're a DUI. If you're less than a .08 and you're over 21, and let's say you're .05, but as an officer of the law that has taken the 8-hour class for the National Highway Transportation Safety Authority, I say, okay, I'm an expert and I think that you're impaired. I can arrest you for being impaired, which puts you into that same consequence. And
then just to clarify, the .08 is 0.08% of your blood alcohol content.
Correct, yes.
So
I have a question though. So even with no test being taken, they're going to take you anyway.
Yes.
If they've seen you weaving on the road, if you're speeding, you have blurry eyes, and you have any kind of scent of alcohol around you, they're going to take you no matter what. Even if you didn't, I'm not going to take any tests or anything. But what happens when you get to the station?
Okay, when you get into the station, that's where, because when you're picked up for that count, or they're charging you with this, then you've got two separate counts, and it's the administrative count and the criminal count. So what happens is when they bring you into the station, they're trying to build a case against you. So when they bring you into the station and they say, okay, now you have to take either a blood or a breath test so that they can determine what your blood alcohol content is to determine whether or not they're going to file charges. Now, if they took you and they threw you in the back of the car and they took you down to the station and you say, okay, well, give me breath, and you get in front of the machine, you blow into the machine, and you're a .02, okay, well, then you know what? I'm going to go back to my car and I'm going to go home. But what they're looking for is, what if you blew, the legal limit is .08. What if you blow a .07? Well, they can say...
Wet reckless.
Exactly.
They've got a whole fallback.
Or they can even go for the A count. They can say you're impaired. Even if
you're impaired, exactly.
And that could be because of bad driving. If you hit a tree or something, you got a .02. They might say, hey, like that .02 was enough for you to hit a tree.
To be impaired, right.
So the A goes down.
Or God forbid, you're a .02 and somebody runs into a crosswalk in front of you on a green light and you hit them. Now it's a felony.
Mm-hmm.
When in fact, the person that was running in the crosswalk was actually the person that caused the accident, not you, but just because you were slightly intoxicated, you become the automatic villain of the case. Right.
Absolutely.
So now, can they make you take a blood test?
Yes, you can. Well, you can.
Because I asked that question because people believe that if I say no, I'm not going to take any tests, that it's all free and clear.
No, you can have, and I mean, I process probably between 500 and 600 of these cases a month, where I've got 500 to 600 people a month that come onto my book. So, and we take in my agency, we listen to the client, we listen to their story, we listen to what they went through. So we've got it from all different directions and all different people about what they've gone through as far as this whole process is regarded. And it's been my experience that when you go when you're apprehended and you're brought in, and let's say you refuse the FSTs, you refuse the PAS, okay, and you're brought into the station and they say, okay, what's it going to be? Is it going to be blood or breath? And you say, you know what? I'm not doing either. You know what I mean? Then they take you into the cell and they hold you down and you're forced to give blood. So now you get the refusal at the station,
which is a year
mandatory 1-year suspension on your license, per the admin per se, per the DMV, and then you have so you get the 1-year suspension on your license and the refusal. But also, what's happened is now they have your blood, so they can spin your blood and figure out what your BAC is. So now the DA has a case to file against you to say that you were under the influence, and you've wound up with the refusal, which means you've lost your license for a year.
And that's a hard loss, correct?
Okay, and here, yes. Lamar refused any test, but apparently they didn't force him to do so, which is kind of interesting because a couple of months ago we did a show in another state, now not in California, there was a ruling that they couldn't force him. But I think California, you can still be forced to. I haven't seen a precedent come up yet on that one. So.
Okay, well, I have a question, Mark. I noticed that we're at our break on our first, and I'm wondering. I think this segment should actually go for another segment. Do you agree with me? Because I think we have John here tonight. I'd like to hear the full perspective. What do you think?
Sure, we can go ahead and do that.
Why don't we do that? Because we have his expertise tonight. I think it's the best for our viewers that they hear the full story here. So, John, now what happens? We have a situation where Lamar Odom, the ex-basketball, probably
Lakers, Clippers,
yeah, whoever, he's played for a lot of different teams, and unfortunately, he's had a downturn. He's refused to take any of the tests at all, and probably the police, out of courtesy, did not force him to take a test. What's he looking at?
The refusal. That refusal right there says it all. He had the opportunity to, when they brought him into the station, he had the opportunity to give blood or breath. Because he refused it, and as I mentioned before, it's broken down into two separate counts. You have your administrative account, and you have your criminal count. Well, they're two completely separate entities. One is administrative and one is criminal. So the administrative count is the DMV. So the DMV says if you have refused to take either the blood or the breath when you were brought down to the station, then we're going to suspend your privilege to operate a motor vehicle in the state of California for 1 year.
Now, is that reversible and under an appeal or anything like that?
No. It's, I mean, I spent a lot of time on the phone with the Mandatory Actions Unit at the DMV, and, I know a number of APS hearing officers and stuff like that. So, I'm always trying to do the best I can for my client, you know what I mean? And one of the biggest, I guess, if you could, one of the biggest hurdles that we have to overcome is the refusal, because the refusal is...
Well, that's like black and white. There's no question. There's no gray area on that, right? Either you said yes or you said no.
Right.
Driving's a privilege, not a right. We all know that.
Yes.
So what is a person facing with their insurance policy on something like that, on when they've refused and they've lost their license a year? Is that how hard is that held against them?
Well, funny you should say that. I've been doing this for about 25 years.
Right.
And I've fell into a situation in my life once where I had to deal with this. And having the relationships with the insurance carriers that I have, I came to the mindset that if I were somebody that found myself in this situation, what would I want an insurance agency or carrier to do for me, especially when I do not understand what it is that I can do? And so that's what permeated me putting all these programs together that I've put together that are exclusive to me for these people. So a lot of times if you're picked up for that 23152B counter A count, the DUI, then I've got programs where I can forgive them for the DUI, and statistically speaking, and I've got hundreds of thousands of clients in my books, statistically speaking, that first-time DUI offender is a better risk than the person with a clean driving record.
Because they haven't gotten one yet.
Because they have not gotten one, and the person who is a first-time DUI offender, their hands are at 10 and 2. They're going to use the blinker, and you know what? When they go to lunch and everybody else is having that martini or their glass of wine or whatever, they're drinking iced tea.
But isn't there a certain, time value, like from the time of your arrest? I mean, I know, for one thing, you've got 10 days from your arrest to, tell the DMV that you want a hearing, or you give up that right to your hearing, right? A lot of people don't know that because they get a temporary license. They stuff that in their, glove compartment and try not to think about it, and then they miss that 10-day limit. So that's one thing that people have to be aware of. But as far as insurance, if this thing goes on for a certain amount of time, they might lose some opportunity in working with the insurance company.
Well, yes, exactly, and that's why it's so important that the people that take that what you're speaking of is the admin per se, the pink sheet of paper they give you when you get arrested. Well, that serves as a 30-day temporary license, and yes, they'll take it and they'll fold it up and they'll stick it in the glove compartment because, you know what, out of sight, out of mind, I don't want to deal with that.
Most people are in denial for a while.
Right, it didn't happen. I didn't.
Yes.
Yeah.
But that 10-day window is crucial because, first off, the most important thing is that you hire private counsel. Because if you go with nothing against the public defender's office, but if you go with the public defender, you have the only thing they can represent you on is a criminal count. You have no administrative representation. So that means that when that case is heard and they plead you out, you walk out of there happy as a lark and you think that the skies are blue and the birds are singing, right? But then you get in your car and you're driving down the street and you get lit up and boom, there's a 1461.2, driving unsuspended because of a DUI, because you didn't bother to file the SR-22, get enrolled in the DUI school, the AB 541 program, and so now your car's going to get impounded for 10 days, you're going to go to jail for 30 days, you're going to go to jail for 10 days, and you've got another $1,600 fine.
And I think another advantage of, if you're an attorney, I've done the DMV hearings, and the advantage is that usually comes up before the court, maybe around the time of the arraignment, but if you're doing a 1538.5, motion to suppress or something like that, generally you can have the DMV hearing prior to that, and it's kind of an advantage to the private counsel because you get to cross your police officer at that point, and he doesn't have a prosecutor there.
Well, there's even more than that. You get the full evidentiary production. You get the discovery prior to that. So what you always want to do is you want to have that filing within that 10-day period, get a first date. All you do is send in notice of representation or request for discovery, and you get that discovery long before you've even gone to court.
Yes.
And so you know exactly what you're facing before you even go to court the first time.
So you're getting a dry run before the criminal counsel even address.
Right.
And so, but it is kind of, the DMV hearings are kind of interesting in themselves because the administrative person from the DMV is not a lawyer or a judge. They're an administrative person. So it's always kind of interesting because they're kind of the prosecution and the judge.
I was going to say they're acting as the judge and the prosecution.
Yeah.
And so the private counsel comes in there and they're trying to defend their client, and they've got somebody that's sitting there saying, I'm the prosecutor. Oh, and by the way, I'm also the judge.
But there's also, you have you could do a writ of mandamus. You could say, we'll do a writ on this and appeal it to Superior Court if the DMV hearing is so out of bounds that you could actually find a
I think what we ought to do is wrap it up for tonight on this subject. But John, I wanted to thank you. I invite you to stay for our next subject.